the room for challenging that order in a higher court expired a long time ago because you have only 14 days to appeal. That's the first answer, Mr. Speaker. The second answer, which is very specific to this process before you, is that the governor went to court. When this motion before you was labeled, she went before the High Court in Meru in petition number 24. No, I'm sorry, Mr. Speaker, I don't seem to recall the number, it's not 24, but she went to court in Meru before the Honorable Justice Cherere to stop this process on that very ground that it was sub judice. The court refused. She returned to the court again, the court refused. She went to the Court of Appeal at Nyeri, trying to stop the process before you, claiming that impeachment cannot be based on matters that are before court. And again, the Court of Appeal refused. Lastly, Mr. Chairman, is how can a convictee whose conviction has not been set aside, who has been disobeying a court order for a year, be the one now telling you everywhere about court orders?
Senator Chute.
Thank you, Mr. Speaker. My question will go to the witness. Mr. Witness, will I be wrong if I tell you you belong to committee maximum because you've admitted before this honorable house that you've been receiving money for months and months illegally, and you've accepted before this house that you've been receiving it illegally? Thank you very much, Mr. Speaker.
You would not be telling the truth, Mr. Speaker, because we have made numerous efforts to be allowed back to office and serve, even through the court, but you are not allowed. The person culpable is the one paying us for service not rendered.
Senator Osotsi.
This is to the witness, Mr. Speaker. Mr. Speaker, looking at the application for this case and even the ruling, the governor is listed as respondent number 3. That is after the county secretary and the Meru County Public Service Board. Is this an admission that the governor is not directly involved in matters of HR, recruitment, and appointment?
It's not an admission.
Senator Roba.
Thank you, Mr. Speaker. I just want to ask the same question, but phrased differently. Mr. Paul Mwaniki Arimi is appearing as a key witness on behalf of the county. The acceptance and accepting the money for this long and appearing as a witness to admit that before this. Why didn't you, consider not accepting if you considered it was wrong? Thank you.
Thank you. It is wrong legally to receive pay for service not rendered or work not done. What we did as victims of this is we have sought legal redress for a full year from last year up to now, seeking to be allowed to get back and work. Yet still, we have not been terminated from work. What you have been given is a mandatory indefinite leave without any reason. So there would be no issue of refunding monies without any clear structures of how this one should be done. So we have been in court, struggling to be allowed to work. The person culpable is this one sending us on a compulsory indefinite leave with even a rider that you will be paid all the services you are home. Indeed, it is depressing.
Just to be clear, witness, this is the question that I help you out. You've indicated that you have received, you've been receiving these salaries.
Yes, Mr. Speaker.
Question from the Senate.
Yes, Mr. Speaker.
And you've indicated that you ought not to have received this money because it is taxpayers' money.
Yes, Mr. Speaker.
So the question that the senator posed then is, did you make an effort
We made
either to
efforts through the
refuse
court.
or to refund?
We did not make efforts to refund, but we made efforts to get back to work.
Very well. Senator Okoiti.
My question goes to Mr. Speaker, sir. My question goes to Counsel for the County Assembly. On trial is the governor of Meru, and one of the grounds is contempt of court. In the evidence that you have laid before this court, are you able to point out to me specifically where the governor is condemned? Specifically where the governor is condemned
Counsel,
or convicted of that contempt?
Mr. Speaker, if you open page 440 of our volume 2, the court order, as you note, and has been pointed out previously, this was a case filed against the governor together with 2 other officials. And whenever this order or even the ruling before it talks about the respondents, every reference to the respondents in this order is a reference to the 3 persons who include the governor. And therefore, where a court, as you find in page 441, it says the respondents who we agree include the governor, paragraph 1 at page 441, the respondents are hereby cited for contempt of this court's order issued on 7th October 2022 by failing to allow the applicants back to their offices. Unless the governor says she was not one of the respondents who are condemned here, then she is one of the people who are condemned, and it is not necessary that she be specifically mentioned when they have been found jointly and severally. That's the legal language, jointly and severally culpable.
Senator Chiranke.
Thank you, Mr. Speaker. Sir, mine is a very quick clarification or guidance from the Council of the Governor. When you look under Article 183, functions of the county executive, which encompasses county governor, county deputy governor, and CECs, I invite him to give me an interpretation of Article 183 in the interest of time, Part C. It says, and allow me, Mr. Speaker, sir, to read, a county executive committee shall, 1, Part C, manage and coordinate the functions of the county administration and its departments. So I want to get clarification and maybe guidance from the council of the, on the part of the interpretation on the role of the county executive or county committee member. Thank you, Mr. Speaker, sir.
Council, did you get that correctly? Did you get the question with clarity?
Sadly, Mr. Speaker, I didn't get the question with clarity. I wondered if the Honorable Senator could clarify the particular aspect of Article 183 that he desires my clarification on. I'll gladly do that.
Senator Chirange, the clarification must relate to what the council handled during the cross-examination. You cannot pick something totally out of that space and seek his clarification. He should clarify on what he said.
Thank you, Mr. Speaker. I needed interpretation of Article 183 1C on the role of county executive vis-a-vis because in a cross-examination, he had indicated that the county secretary should be the one being impeached instead of the governor. That's why I'm inviting him to clarify under Article 183 1C on the functions of the county executive. Thank you, Mr. Speaker.
Council.
Thank you so much, Mr. Speaker. Very briefly, the government, either the national or the county level, is a complex whole, but our constitutional and legal order recognizes that government works through the agency of state and public officers, and wrongdoing in law is individual. Wrongdoing in law is not collective. It's in that respect that we beseech the county assembly to give us a case that shows the individual wrongdoing of the governor or the imputability of the acts of any other functionary in the county government to the governor. The governor is here on trial. You try people for their wrongdoing, and that's my humble view. And thank you so much, Mr. Speaker.
Senator Muma.
Thank you, Honorable Speaker. My question is to Council for the County Assembly, and it's in respect of the clip that was played here. Is it your view that a leader takes responsibility for utterances of their spouse?
If it's a strictly legal question, Mr. Speaker, of course, the law was changed a long time ago. Spouses don't take responsibility for the actions of the others. But that's as far as the legalese and the splitting of heirs is concerned. The matter before you is not about criminal or civil liability in a court of law. It is about accountability. It is about the values in our constitution. If a governor perpetually provides a forum through which our spouse is making utterances that are inflammatory, that could easily lead to violence, as we'll show you, and it is a function hosted by the governor, and on each occasion, the governor does not disown those statements. In the case of the musical performances, we'll show you the governor even dancing and enjoying the music, demonstrating to the huge crowds when wivu wajinyonge. That is why, Mr. Speaker, when you read the motion before you, it is not talking just about specific acts of the governor. It is also talks about complicity and condoning. If we were in a court of law, we would call it aiding and abetting. But because it's not a court of law, that's why we have chosen the language complicity and connivance in things. First of all, it's a program, it's a session held by the governor. And if that were the law, even in a court of law, Mr. Speaker, and our laws on ethics and integrity, there is indeed, if you see the laws we have cited, a provision for acting through others. And in this case, we want to suggest to you that the governor was acting, as was the case before when we were here, through her husband. Thank you.
Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, I would like the counsel for the county assembly to help me. And I'm happy to be reminded that he teaches law to our children. Mr. Speaker, the country has seen in that video that the governor of Meru was not in that video. Her voice was not heard in that video. So what I would like you to help me, teacher of law, is the legal high standard of fishing expedition. Would you like to stand down that video purely because your witness has confirmed to this Senate and the whole Republic that the governor was not there, her voice was not heard? And if you still stand that you don't want to stand down the evidence, do you want to teach students at the university that they can edify something that lacks moral and intellectual instruction to a council?
Mr. Speaker, I've now found the volume setting the relevant law. It is volume 3 of the County Assembly's document in answer to the question by the Honorable Senator Kalwale. At page, I believe, 37 of our Bado volume 3, we have reproduced section 24, page 37 of the Assembly's volume 3. We have produced section 24 of the Public Officer Ethics Act. And it is clear from that section 1, for purposes of compliance with chapter 6, one can take responsibility for acting through others. And in this case, we humbly submit the governor has been acting through her husband. Number 2, this is how, Mr. Speaker, you know the governor was acting through her husband. In October 2022, the husband is seen on the video saying, "These officers shall never return to office, court order or no court order." And true to his utterance, the governor ensures that they don't return for a full 365 days. And while at it, Mr. Speaker, in any event, I keep repeating, there is a conviction as we speak. And that conviction is res judicata. That is to say, that matter is closed as a legal question because it has not been appealed to a higher court within the time required by law. So as we speak right now, the governor is actually a convict. And those are not my words. There is a court order to that effect.
Now, honorable senators, we have 6 more witnesses to call. And if you read the program, we are supposed to stretch it to 7 p.m. And therefore, I will take one clarification from this side and another one here. Most of these clarifications, you'll pick them as we hear the witnesses. Senator Haji Faki.
Mine is to both the council and council for the county assembly and the witness. There were proceedings before the High Court in Meru where the county secretary, according to the judgment and according to the ruling, was found to be guilty of contempt. And the matter is still ongoing. The punishment has not been meted. Now, is in that subjecting the governor to a double jeopardy, because he is facing the proceedings before the court in Meru are still alive. And counsel for the governor said earlier that they were actually in court this morning. And here we are, you want us to impeach the governor based on the same set of facts. Isn't this a double jeopardy, which in law is not allowed? Thank you.
Mr. Speaker, that's a legal question. I heard it was addressed to both me and the witness. I don't know whether the witness is able to answer.
Proceed. He belongs to your side. You can answer for him.
First of all, Mr. Speaker, it is not correct to say that the question of whether the governor is guilty of contempt is in court. What is in court is the question of sentencing. The question of liability is settled. The only other thing that is in court is the question of purging the contempt. So there is no question of double jeopardy. As a matter of fact, Mr. Speaker, the rule of double jeopardy does not apply to proceedings of impeachment. There are several rulings by the Supreme Court itself that says, and I can quote the Sonko case, the Martin Nyaga-Wambora case, that say impeachment is not about civil or criminal liability. It is about political accountability. It is about ethics. It is about the type of leadership, the type of persons we want holding certain offices. And that is why you find the Article 181 is about may be removed on any of the following, and it talks of gross misconduct. Gross misconduct need not even be a criminal or civil offense. It can be anything that attracts serious moral censure. It talks of gross violation of the Constitution or other law. And in short, all we are saying, the Supreme Court has already answered this question of double jeopardy. And that is why even the Court of Appeal itself and the High Court in Meru, guided by the Supreme Court, refused to stop this Senate from sitting on these charges and making it whatever decision it will make, because the courts have already confirmed it is not about legalese and splitting legal heirs or civil or criminal liability. It's a question whether the governor accused of the things we are accusing her and which will prove is the type of governor we want to see holding a public office within the meaning of Chapter 6 of our Constitution. It is not a legal matter, Mr. Speaker. And I'm lastly told, if this can be let to happen, then all I need to always avoid impeachment, which is actually what the governor tried to do at the High Court and the Court of Appeal, why she failed. All I need to ensure as a governor, if this were unanswered, to ensure Article 81 is dead, is to ensure whenever I commit a breach of the Constitution, there is a court case like happened in this matter, where proxies were obtained to file various suits in court so that they can come under the pretext. And even in your own standing orders, Mr. Speaker, as well as those of the County Assembly, you note the mere fact that a matter is in court does not stop the Senate or even the National Assembly. You can even take notice, Mr. Speaker, that as we speak, there has been a matter in Shakahola, which is in various courts, criminal courts, and I've seen committees of parliament examining the same persons who are facing not just employment courts here, but actually criminal courts, and nothing has stopped either the Senate or the National Assembly. And that is why even your standing orders give the Speaker the latitude to decide whether a matter that is in court should nonetheless be deliberated upon and a decision made by Parliament, in this case the Senate, as the representative of the public conscience.
Lastly, Senator Veronica.
Thank you, Mr. Speaker. Just a clarification from the council for the County Assembly of Meru. We have seen this judgment. Is it a ruling, the one that you are relying on the contempt proceedings? And 37C on page, I think you know where it is. 37C talks about the respondents not having the audience of the court until the contempt is purged. I think the witness has confirmed that he's now being paid. They have been reinstated, or did I get it wrong? I hope that's a correct position. Council, do you treat that as a purge to that contempt? Now that that is no longer, those offenses are no longer taking place and they have been reinstated, would you treat that as a purge? And I know that the sentencing is awaiting before the court. And if the sentencing is awaiting, would you still say the matter is not pending before court?
Mr. Speaker, then being denied audience is part of the standard government as we speak. I use the word attempted because the witness told you the letters appointing his replacements have not been recalled. They have not been rescinded, so that as we speak, we have the witness here and his 3 colleagues who are the substantive office holders, and then we have the other persons who are also in acting capacity. The purging of a contempt, Mr. Speaker, is something in the realm of mitigation of sentence. That's why you're denied audience until you purge it. So the fact that someone has purged the contempt does not undo the conviction. The conviction still remains, and as we speak, even if she purges and apologizes and recites whatever prayer about it, it will always remain the record of the court that she was convicted and that conviction has not been set aside.
And this witness at that. Now, as we prepare to usher in the second witness, pursuant to Rules 23 of third schedule of the Standing Orders of the Senate, as a speaker, I do not have that latitude to ask for any clarification or ask questions. However, if the integrity of the institution of the Senate is at stake, then as a speaker, I need to guard it. Counsel for the County Assembly, your allegory, the Russian allegory, that when the man was asked to say something, he said Russia don't know how to do things, and that's why he was alive. That statement, in its ordinary meaning, could be understood, and indeed it was understood, and that's why Senator Mungatana rose to ask that question. It was to mean that the Senate did not do a good job in the first impeachment. I don't know, counsel for the County Assembly, whether you still want to have that allegory as part of your record, or at this juncture, you want to take it away from the record.
Mr. Speaker, my allegory was not a slur on the Senate. It was, as I said, about a person who was lucky to escape a certain fate, and instead of refraining from utterances that had placed him in that fate, continues doing it after the rope breaks. And I was clear in my allegory that even in Russia, this was understood to be an act of providence, that the man in question was lucky. It is our submission that if the governor, Kawira, was lucky to be acquitted of certain allegations, the least anyone would expect of her is to refrain from the behavior. So I didn't mean in any way to slur the Senate. In the event that I am misunderstood as criticizing the Senate's decision, then I offer an unqualified apology, and I'll be open to even the expansion of the relevant allegory. And since it seems to cause too many issues, I seem to have been misunderstood, Mr. Speaker, I beg that it be expunged.
Kindly usher in the second witness. Kindly proceed to swear in the witness.
I, Evans Moira Karia, do solemnly affirm that the evidence that I shall give before the Senate in respect of the matters before the Senate shall be the truth, the whole truth, and nothing but the truth.
Sir, please tell the Senate your full name and what you do for a living for purposes of your identity and the record.
Thank you, Mr. Speaker, sir. My name is Evans Moira Karia. Currently the MCA for Mitungu Ward, that is in South.
Mr. Perhaps I could beg we be given a small table where I could place my battles because I will otherwise be constrained to keep picking things from the floor.
At times, Sergeant at times, kindly help counsel. Make him as comfortable.
Can you confirm that you are the mover of the motion before the Senate?
I confirm, Mr. Speaker, sir.
Can you also confirm that of the affidavit?
I confirm.
On what page can we find your affidavit, sir? Yes, this is much better.
Yeah, this one affidavit is on page 33 of volume 1 to page 36 of volume 1.
The signature at page 36 is your signature?
Yes, I confirm.
Now let's go that you have made in this impeachment motion?
Yes, it does.
Would I be right to say, sir, most of the payments there are actually prepayments?
Most of them are around 171 entries are prepayments.
Are there any payments on this document shown to any of these relatives of the governor?
Yes, there are several prepayments made to the relatives of the governor.
I'll show you a few for illustrative purposes. At page 20, somewhere just below the middle is there, and around the middle, are there payments to Nefert Kenyu?
Yes, we have one. There is
At page 21, do we have several payments payable to Rose Kinyagwante?
yes. For example, we have one under voucher number 66 524 to pay to Rose Kenyo Guantai.
You will confirm, sir, because we are constrained for time,